What now?
How you gonna send me downstairs like I'm the one making the noise or not? You don't know who was back there talking. I wasn't the only one talking.
Well, first and foremost, the bailiffs, the sheriff's deputies who are operating as bailiffs are the ones who control that pod there where the prisoner.
This courtroom just erupted, and it's not your usual outburst. Meet Shireek, Mark Vaughn, a defendant who insists he's the only one talking, literally. Today, he's representing himself against the state of Tennessee, arguing to withdraw a guilty plea, question his attorney's pay, and even demand YouTube videos as court evidence. But here's the twist. The judge actually grants part of his motion, something that rarely happens in real courtrooms. Stick around, because by the end of this hearing, you'll see how a simple motion spirals into a full-on legal chess match and a defendant who refuses to play by anyone's rules but his own.
Appeal, and we'll deal with that. But the first and foremost thing is the motion to withdraw your guilty plea. In the case that we tried last week, you had pled guilty to the driving on a revoked license. So if you want to address that issue, then I'm going to let you take up each one of your motions. I have a motion to withdraw your guilty plea, a motion to continue the sentencing, a motion for a transcript and all judgment papers, and a motion to compel evidence, including copies of YouTube videos. So we're going to take those up in that order. So if you'll come to the podium, I will hear what you have to say on each one of those motions.
All right, what was the first one again?
First one is your motion to withdraw your guilty plea. At the trial, you were charged with driving on a revoked license, third offense, and then count 2 was dismissed and count 3 was retaliation for past action. Prior to the commencement, well, actually when the indictment was read, you entered a plea of guilty to count 1, driving on a revoked license, third offense. So that waived your right to contest the issue of whether you're guilty or not guilty of that. Obviously, there's not been a sentencing hearing on that, so you would still have the right to appeal whatever sentence I imposed in that case, but you would have waived your right to contest your guilt or innocence of driving on a revoked license.
I object. The rule states that you can place a withdrawal of guilty plea before sentencing, and we haven't even been to sentencing yet. So that I'm well in the rights to withdraw my plea to guilt. I was under the pressure of my assistant counsel, and I feel like that he gave me some bad advice, and to withdraw is well in my right to do so.
Well, it is within your rights to request to withdraw your guilty plea. It is not an absolute right. You have referred to Rule 32, and I'm going to let the state just address these motions from the chair where she is so that you don't have to keep walking back and forth. But I will let you address each one of those motions, and then I will let the state address those motions, and then I'll make my ruling. So that was your argument, is that you want to withdraw it because you think you got bad advice from Mr. Spratt?
Yeah, and it's just the pressure of my first time doing this, Your Honor. I fully didn't understand what was going on. There was a lot of other things going on at the time. I was doing my best to keep up, and that was like a spare moment decision. And
okay, I understand. Let's move on to the second one. You have filed a motion to continue the sentencing in your case. Your motion to continue sentencing states that you're requesting a continuance in the sentencing, that you want time to prepare some preservable rights for appeal, and that the delay is only requested to receive the transcript from the trial. All right. I understand. Is there anything you want to add to what you've written there?
Yeah, basically, requesting for a continuance because I plan to put in a motion for a new trial, and without the facts of the dates and the circumstances, what he said and she said, I mean, I couldn't give you a good, well drawn up motion for new trial to properly preserve for appeal.
All right. You want to request a transcript of the trial, is that correct?
Yes, I want a transcript of the trial, and I want any and all papers filed in by myself and the public defender and my paid attorney. This is not the first time I've put this into the courts. It goes along with filing for new trial. There's due process errors and other errors that the record can show, and it's in the possession of the courts.
Right. Then I will hand you a copy, Madam Clerk, if you will raise your right hand. You solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth, so help you God. That is a motion to compel evidence, and you state that you want copies of you want all YouTube videos to be made available on USB or playable DVD or CD from the date of your arraignment to date. Those videos are relevance to your appeal. All right. Anything you want to add to that?
It stands for the same reasons that for all papers, to your honor, the same exact reason.
Okay. If that's all you have to, if there's anything else you want to add to those motions, that's what we're hearing today.
Is that I guess that she said it was all from, that's all from arraignment date?
I'm sorry?
Is that all from arraignment date?
Everything in your file, that would start with the arraignment and come forward, yes.
Okay.
Let me, before you leave the podium, you had previously made reference to and filed a motion for a speedy trial in your cases, and I'm prepared to give you a trial tomorrow on the on the failure to appear case. That is one of the three remaining charges, and I'm looking at a date later in the month for the trial on one of the other remaining charges so that we may comply with your request for speedy trial.
What are the three remaining charges, Your Honor?
You have docket number 2021 CR 462, which is aggravated assault. Count 1 through 6 is aggravated assault while displaying a weapon. Count 7 is reckless endangerment using a deadly weapon. Count 8 is reckless endangerment with a deadly weapon involved. Count 9 is possession of a firearm by a convicted felon. Then the case 336 is the one we tried, and that's the one we've dealt with so far. Docket number 337 is count 1, simple assault, count 2, false imprisonment, count 3, disorderly conduct, count 4, public intoxication, and docket number 2024 CR 142 is a single count of failure to appear. So that is the case that I understand the state can be ready to proceed on tomorrow, failure to appear.
Okay.
All right?
Yeah, I'll be ready for that. I do have a request of the courts, though. I still have some video evidence at the jail. And
Video evidence of what?
Of the discovery that was in my discovery packet at the jail, and they're under the impression that I don't have any more court. When I asked to view it, they're telling me no.
Well, they'll be notified that you've got trials coming up. The trial tomorrow is a failure to appear, which shouldn't have any video evidence that would.
No, that's understandable, Your Honor. I don't understand where they're getting their information that I'm through with courts, and it's hindering me to be prepared when I come to court.
But we'll make sure that the bailiffs relay to the jail and that the clerk relays to the jail. You do have other cases pending. State is trying to determine whether or not they can have a trial on the 23rd and 24th of any of the remaining charges. Let me advise you that the trial that we're going to have tomorrow on the failure to appear will be by jury, but it will be a different panel they won't be the same jurors. In other words, they won't know anything about your prior case. So we have 4 panels of the jury group that was brought in. Group 1 was their first trial. Group 2 will be our panel 2, as we call it, will be the panel that will try your case tomorrow.
It would be the ones that was left over?
No, they weren't here that day at all.
Okay.
So they weren't brought in. We bring them in groups, panels. So the ones that'll try your case tomorrow will be a different group.
Okay.
All right. He needs to make sure he has his dress clothes to be able to dress in tomorrow. So.
Okay. Are we going to make a ruling on the rest of the motions today, Your Honor?
I'm going to make a ruling on your motions today after we hear from the state.
Okay.
All right. Thank you. If you'll have a seat.
Okay.
Judge, on the motion to withdraw guilty plea, I searched for case law that was on point where a plea was entered in front of the jury, and there's not a lot out there. I did not find a single case with those specific facts. I did find, and of course it is my duty to tell the court any case law that I find that is against my interest. There is substantial case law that talks about how the defendant must be notified of all his rights in a waiver and waive them knowingly and voluntarily and say that on the record. I don't think we did a rights waiver in this case, and so I leave it to the court's discretion if that would be reason for the withdrawal of the guilty plea. Based on how you rule on that, with the sentencing, normally the defendant would not need to file a motion for new trial until after the sentencing. So I don't know that he needs transcripts before we do the sentencing, only before he would file a motion for a new trial. So the state would be ready for that when the court chooses. And then you have handled the other two motions on your own, unless you want me to address either of those other two.
That's all right. Just want to give you an opportunity if you want to be heard.
Thank you, Judge.
All right, on the motion to withdraw the guilty plea,
And there it is, a major win for Mr. Vaughn. The judge just granted his motion to withdraw his guilty plea. That's not common. In most states, withdrawing a plea after entering it is tough, especially when done in front of a jury. But notice the judge's reasoning. Vaughn may not have fully understood his rights when pleading guilty, which falls under what's called a Mackey rights issue, meaning the court didn't properly ensure the plea was voluntary and informed. The judge even admits better procedure could have been followed. That transparency is rare. So while Vaughn might not always win friends in court, today he just scored a procedural victory that could reshape the rest of his case. What do you think? Fair call or lucky break?
he said he did not realize he could not appeal from that guilty plea. Well, he can appeal the sentence imposed, but he cannot appeal the finding that he's guilty of driving a revoked license. But because of the fact that essentially Mr. Vaughn is arguing that he was not fully aware of his rights, and because, as the state pointed out, normally this is done prior to trial with a what we call the Mackey rights, where I explain all of the rights and go through that litany of rights that they have prior to accepting the plea. The only other option would have been to have suspended the reading of that indictment to the jury and his response, send the jury out of the room, and then conduct that. And probably that would have been the better practice. So I'm going to grant his motion to withdraw his guilty plea as to that driving on a revoked charge, and we'll place that back on the docket in a separate, it'll be tried separately than anything else. So essentially you're going to have a separate trial on that charge. The motion to continue your sentencing, I'll grant that as well, so that you have time to be able to do whatever. When did we set the sentencing hearing, Madam Clerk? Do you remember? We have not. All right, we'll set it in January then to give him sufficient time. That ought to be more than enough time. Sentencing hearing will be on January the 28th at 1 o'clock.
You write this down for me. You flip that paper over right there.
Then the next motion is for a motion for a transcript and all judgment papers, which I have supplied to you. And then the last motion is a motion to compel evidence, which is arguing that you should be entitled to a download of all YouTube videos. This court finds that those YouTube videos are in the public domain. They are not evidence that was utilized in the trial of your case. And for that reason, this court does not find that there is any obligation on the court or the state to download and go back through and every hearing that you've had. You have a right to transcripts of hearings if it gets to the point where you are going to ask for a transcript of the proceedings, but you do not have a right to a broadcast of the proceedings on YouTube. The transcript of the evidence would be sufficient to show what happened in court. The Court of Appeals does not consider a YouTube video. They don't watch videos when they consider an appeal. They refer to the written transcript and the exhibits. So your motion as to the YouTube videos being compelled to be brought before you, I am denying that motion. That concludes all of the motions that were set before the court. We determined that we're going to try the case of failure to appear tomorrow to a jury. So we will allow you to resume. You still want to represent yourself?
Of course. I do have a question for you.
What is that?
Mr. Lee Spratt continued to stand up on my trial day, and he made the statement about not being paid to do so. Well,
Correct.
From my studies and what I was looking up, it stated that over in the I can't remember the rule exactly, but it stated that all appointed attorneys were paid. Is there any knowledge of yours?
Yeah, I can tell you that he was not appointed as the attorney of record for your case. He was designated as advisory or elbow counsel. There's a difference. His obligation is not to represent you in the case and to, handle the trial. He is there only to answer questions or to give you suggestions. So as a result, it is my understanding and my belief that that he does not get paid for that. And so for that reason, as I pointed out earlier, advisor, you've elected to waive your right to have counsel represent you. And I've reiterated that question to you on more than one occasion. And again today, if you want to represent yourself, you have indicated, of course, so you plan to represent yourself. By saying that, you are waiving your right to have an attorney represent you. You do not have an absolute right to advisory counsel. It lies within the discretion of the court. I allowed Mr. Spratt to continue in your case as advisory counsel to help you through the process of jury selection, the trial itself. And after that, Mr. Spratt is relieved and has no further obligation, even as advisory counsel. So you are on your own and you will be representing yourself until such time as you make the decision that you want to have an attorney. And when you do that, I will appoint an attorney who will take over and will handle the case. And you will simply be, listening to that lawyer, and that lawyer will be able to tell you what is going on and give you advice about that. But he or she will be handling the case.
That will not happen.
Pardon?
That will not happen.
Okay. Well,
Ever.
I understand you have every right to represent yourself under the Constitution of this nation. And I am going to give you that opportunity. But you understand what you've been through, that there are complexities about jury trials that sometimes can be very difficult to understand.
There's nothing to understand. What I understand is that the poor representation this court keeps providing. That's why I'm asking you about the elbow counsel saying that he wasn't getting paid. He should have been getting paid. He was appointed, you saying elected, appointed is appointed, whether first seat or second seat. And he could have done more than just show up. That's all he did.
Well, you can take all of that issue about whether or not he gets paid up with the administrative office of the courts. I'm not the one who pays him or doesn't pay.
Okay.
All right. Then we are concluded for our business today, and we will resume this case. We'll resume the court tomorrow at 9 o'clock when we have a jury coming in to try this failure to appear case. We stand in recess, or adjourn, rather.
In the Circuit Court for Dickson County, Tennessee, at Charlotte, September term, Grand Jury, 2024. The grand jurors of Dickson County, Tennessee, duly impaneled, sworn, and upon their oaths do present that on or about July 24th, 2024, in Dickson County, Tennessee, and prior to the finding of this indictment, Sharik Marquis Vaughn then and there did unlawfully and knowingly fail to appear in the Circuit Court for Dickson County, Charlotte, Tennessee, as directed by the Circuit Court for the purpose of attending an official proceeding, to wit, trial date for docket cases 22 CC 2022 CR 336, 2022 CC 22 CC 2023 CR 227, and 2022 CC 2021 CR 462 in violation of Tennessee Code Annotated 3916-609 and against the peace and dignity of the state of Tennessee. Signed, W. Ray Crouch, Jr., District Attorney General.
Mr. Vaughn, to that indictment, how do you plead?
Not guilty, Your Honor.
Plea of not guilty is entered. The next step will be for the opening statements of the lawyers or of Mr. Vaughn, if you choose to do so. General?
Judge, I'll waive an opening.
Mr. Vaughn, do you wish to make any sort of opening statement?
No, sir.
All right. Opening statements have been waived. Therefore, the state may proceed with its proof. You may call your first witness.
State will call Pam Lewis.
Ms. Lewis, if you'll come forward, please.
Are you Pam Lewis?
Yes, ma'am.
And you are our Dixon County Circuit Court Clerk.
Yes, ma'am.
How long have you served as the Circuit Court Clerk?
Since 2002.
And what is the general duties of a Circuit Court Clerk?
General duties of the Circuit Court Clerk is to maintain the court records.
And either you or your staff are present for all circuit court dates.
Yes.
And in this case, we are here, Sharik Marquis Vaughn is on trial. And we're going to be talking about him. Is he here in the courtroom?
Yes, ma'am.
Could you point to him?
He's sitting at the defense table.
Judge, if the record would reflect that she's identified the defendant.
Record will so reflect.
And did the defendant have a trial date set on July the 24th of 2024?
Yes, ma'am.
Okay. And he had 3 cases set for trial that day?
Yes, ma'am.
And when someone has a trial date coming up, how do they know that they have a trial date coming up?
When they come to arraignment, we check to see if they need an attorney, and then they are given a plea date and a trial date.
And what was the date of the immediately preceding court date for the defendant? So when was the last time he was in court before that July 24th trial date?
July 19th.
And that was here in Dixon County,
Yes, it was before Judge Lockard Mash.
and he needed to appear in the same courtroom that on July 19th as he was on July 24th.
Yes, ma'am.
And was his court date announced on that July 19th date?
Yes.
Now, would he have known about the trial date before that July 19th date?
Yes, he was notified in March of 2024 when Attorney Flanagan filed a motion to withdraw his counsel.
So he was aware of the court date in March and then was in court, let's see, the 19th to the 24th, 5 days before his trial date.
Yes.
Now, on the date of a trial, such as the one scheduled on July 24th of 2024, does your office bring in a jury panel?
Yes, ma'am.
And was a jury panel brought in for this trial?
Yes.
And did the defendant show up for his court date on July the 24th of 2024?
No, ma'am.
And you have reviewed all 3 docket sheets for all 3 cases listed on the indictment?
Yes, ma'am.
And he was not present?
He was not present.
Judge, that's the state's questions for this witness.
Mr. Vaughn, do you have questions you want to ask of this witness?
I do.
All right.
Okay, I believe you just stated to Ms. Bryson that your job title is to maintain court records.
Yes, sir.
Okay, what type of records are they? Like,
We have criminal records, civil records.
okay, are you biased against me?
No,
You are not?
no.
Okay. Do you recall speaking to? Are you familiar with who Scott Tummins is?
Yes, he's a bondsman.
Yes, he's a bondsman. Did you happen to speak to him at the time when I was alleged not to appear?
No, sir.
Okay, I don't have it with me. I have, on some of your records, it says that you spoke to Scott Tummins and as well to Lee Spratt. You not recall your record saying that?
No, sir.
Okay, it says that, that the copy I have, that you spoke to Lee Spratt and Lee Spratt spoke to you and said he had no contact with me.
That was the day of the trial. He announced he had no contact with you.
Okay, is Lee Spratt my elbow counsel?
He was, yes, sir.
He was my elbow counsel?
Yes, sir.
So he can make statements on my behalf and testify on my behalf?
Yes.
He can, without my lead?
No, not
Oh.
without your permission.
Okay, so he did that free will?
I guess so.
Okay, you said that you keep record of everything filed into this court, have I ever filed a complaint against you?
No, sir.
Have I
nothing.
filed any paperwork to have you recused or anything in this court?
Yes, I do believe you did.
Okay, I did. Okay. Was I ever charged with another failure to appear out of this court?
I don't believe so. Not that I remember you haven't been.
One that I back, I want to say last year, and I was released upon out of this court.
Let me think. On July 19th, the day you was here, that Judge Lockren Mash reinstated to your bond. That was the day they dismissed the first one because you gave reason why you did not show up the first time.
Correct.
That was prior to the July 24th.
Correct. And
Yes.
what was the reasoning for that one?
I do not remember what reason you gave.
Could it possibly been some messed up paperwork?
It could have been.
Okay, what about this time? Do you think that could have possibly been?
No, sir. No, sir.
Your Honor, that's all.
Mr. Vaughn, the state has rested their proof, so the next question is whether or not you want to present any proof. I want to go through your rights as a defendant to make sure you understand what your options are. We did this at the last trial, so I'm sure you're familiar with it. But I'm going to ask you to raise your right hand and let me place you under oath for the sole purpose of this examination. All right. Mr. Vaughn, you are representing yourself, but even as a defendant representing yourself, you have the right to testify at a trial, at this trial. And if you choose to testify, then no one can stop you from testifying if you want to give your version of the events and so forth. Likewise, you are not required to testify, and no inference of guilt will arise if you choose not to testify. No one can make you testify if you don't want to testify. So the question becomes, do you wish to testify at your trial, or do you want to waive your right to testify?
I'll waive it.
You're going to waive your right to testify?
Yes, sir.
All right, then have a seat. Bring the jury back. All right, ladies and gentlemen, the state has now rested. Mr. Vaughn, you as the defense have the right to present proof. Do you wish to put on any proof?
No, sir.
All right, then the state has rested, the defense has rested, so you will now hear if there's any closing arguments that the sides wish to make, then you will hear from them.
Ladies and gentlemen, this is probably the shortest jury trial that has happened in this courtroom. It's okay, you don't have to. The defendant is charged with failing to appear on his trial date, July 24th of 2024. You have heard testimony that he was in this courtroom on July 19th, just a few days before that, where he would have known of his court date, and that just a few days later, he failed to appear for that court date. And as such, the state will ask you, you're going to receive instructions from the judge and a jury verdict. You'll go back and elect a foreman, and the state will ask you to return a guilty verdict for failure to appear. Thank you.
Mr. Vaughn, you have the right to address the jury, but you may not testify. You may only argue about the facts.
You just heard me ask the witness multiple questions about whether she was biased and whether I filed a complaint against her. She testified that I have. You've also heard that I've been charged with failure to appear out of this court before too, and it was also dismissed. You've also heard that I've asked the witness whether there has been errors made before in my case, and you also heard her state yes. I'm asking y'all to take this and do the best y'all can. Thank y'all.
All right, ladies and gentlemen, this will be the final charge of the court. The defendant, Sheriff Marky Vaughn, is charged in the indictment with the crime of failure to appear. The defendant pleads not guilty to the indictment and the offense contained therein. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully
And that
consider
wraps up
all
one
of
of the
them.
most
The order in
unpredictable
which these
courtroom days
instructions
we've
are given
seen. Vaughn
is no
fought the
indication
system
of
at
their
every
relative
turn, questioning
importance.
evidence,
You should not
debating
single
legal
out one or
procedure,
more
and
of them to
insisting
the
on defending
exclusion of
himself.
another or
Yet
others,
the
but
judge
should
remained
consider each
remarkably
one in the
patient,
light of
even
and in
granting his
harmony with the
motion to
others.
withdraw the guilty
The
plea
law
and setting a
presumes that
new
the
trial
defendant
date.
is
But
innocent of the
representing
charges
yourself,
against him.
that's always a
This
high-risk
presumption
move.
remains with
Today's
the
ruling
defendant
might have
throughout
given
every
him a
stage of
second
the
chance,
trial and
or
is
just
not
delayed the
overcome
inevitable. What's your
unless from
take?
all of the
Was
evidence
Vaughn
in the
standing up
case
for
you
his
are
rights,
convinced
or
beyond a
digging
reasonable
himself
doubt
deeper?
that the
If you
defendant
found
is
this
guilty.
breakdown as fascinating
The
as we
state has the
did,
burden of
make sure to
proving the
hit
guilt
that
of the
like
defendant
button,
beyond a
share your
reasonable
thoughts
doubt,
below,
and this
and
burden
subscribe
never
to Law
shifts,
Clips
but
for more
remains on
real
the state
courtroom
throughout the
moments.
trial of the
Explain.
case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability, after such investigation, to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Dixon County, Tennessee, and that it was committed before the finding and returning of the presentment in this case. The burden is upon the state to prove by a preponderance of the evidence that this offense was committed in Dixon County, Tennessee. Proof by a preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dixon County, Tennessee, then you must return a verdict of not guilty. As heretofore stated in the indictment, the defendant is charged with the crime of failure to appear. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant knowingly failed to appear, and 2, that the defendant had been directed to appear by a lawful authority, and 3, that the defendant had been released from custody with or without bail on condition of subsequent appearance at an official proceeding at a specified time or place. Custody means under arrest by a law enforcement officer or under restraint by a public servant pursuant to an order of a court. Official proceeding means any type of administrative, executive, legislative, or judicial proceeding that may be conducted before a public servant authorized by law to take statements under oath. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that the person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. If you find the defendant guilty of a failure to appear as charged in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, you shall acquit the defendant of this offense. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. During your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The verdict must represent the considered judgment of each juror. To return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you will first select one of your members as foreman or forelady who will preside over your deliberations. When you have reached a verdict, you will return with it to this courtroom, and your foreman or forelady will announce it. In reaching your verdict, you shall consider the offense charged in the indictment. If you unanimously find the defendant guilty of the offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense as to the defendant. On the other hand, if you do not find the state if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. In that event, your foreperson will report that you find the defendant not guilty. If after your deliberations you find the defendant guilty, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. You may now retire to begin your deliberations. Ladies and gentlemen, I have prepared a verdict form that will go back with the original of the charge, and it simply finds a place. It just provides that in the indictment for the charge of failure to appear, we, the jury, find the defendant, Sherrick Markey Vaughn, either not guilty or guilty, and you check one and the foreman signs it. So, ladies and gentlemen, if you will step across the hallway, you may begin your deliberation. All right, while we are here, General, we have discussed trying to conduct another one of Mr. Vaughn's trials on the 23rd and 24th of this month.
Yes, Judge. One of my victim witness coordinators is calling this morning to all of the witnesses in the simple assault case to confirm their availability for that trial. I've not had a chance to see if she's got in touch with everyone.
As soon as you know anything, if you can find out before we are adjourned today, I would appreciate those. Mr. Vaughn needs to know if he's going to trial on the 23rd and 24th.
Is my witness still to need to be subpoenaed for
Which
that?
witness is that?
Jennifer Dozier, I placed in a motion for her to be at every one of them, every pending case.
I don't know. We need to make sure that Ms. Dozier was subpoenaed for this trial, the next trial. Problem is we don't have a trial date, so it's hard to subpoena somebody to let them know they have to be somewhere when we don't know what the trial date is. But there should be a subpoena issued for her. Is she still in Savannah?
Yes.
All right. All right, Mr. Vaughn, if you'll step back with the officers, we'll bring you out when the jury is returned.
I have a quick question, if I could, Your Honor. This is about yesterday, if I can just gain some clarity.
All right.
I haven't had the chance to go through that paperwork yet. Was a transcript in that paperwork
A transcript of what?
of the proceedings? Was that in that
Are you
paperwork?
talking about a typewritten transcript?
Yes, sir.
No, that was not provided. What was provided was the entirety of your file here in the court. As far as if you're asking for a transcript of every time you appeared in court, that will be a lengthy procedure to have to identify what days we're talking about. Then the court reporter would have to have a sufficient length of time to type everything up, which will be a very difficult thing for her to do on a short-term situation. So. Okay. All right, so there's an order granting you a transcript, but you don't have it yet.
For which days, Your Honor?